Ready? All right. We up? All right. Well, welcome everybody to tonight's class. We're going to be talking about the standard offer to purchase and contract, the Form 2T. As we go through it page by page, we're going to talk about how you may fill it out, what it means, so that way when you have a client that's ready to make an offer, or if you're on the listing side and you receive an offer, you know kind of what this contract states. Is it filled out properly and completely? And that way, hopefully, to make you a more informed and educated agent to become more successful in the future. As we're going through it, if you here in the class tonight have any questions, just let me know. We'll stop and answer them and go over them. Otherwise, we'll just keep going through. Sounds good? All right. Well, we'll start with, of course, page 1. This is the standard offer to purchase and contract. At the top, it talks about terms and definitions. This contract is between buyer and seller. So that's where you would put in who the buyer is and who the seller is. Then next, it goes into talking about the property. There's 2 check boxes for these next 2 questions. First is, will the property include a manufactured mobile home? Yes or no? Next is, will the property that is being conveyed include an off-site or septic lot, boat slip, garage, parking space, or storage unit? Yes or no? Next, it goes on to the address, the city, the state, the zip, the county, and then it gets into other descriptions of the property to make sure that we are conveying the appropriate property. As far as the legal description, the plat, reference, the subdivision, the parcel ID number, and then also the property's deed, book, and page that correlates with the property. All of that information you can find on the tax record. So it is all there. Just have to know where on the tax records to look for it, but it is there for your reference. Next, we get into the purchase price, the big things, the numbers. What is their offering on the property? First line would be the actual whole purchase price. The next lines are your 2 main deposits. First is your due diligence deposit. How much is it, and how is it being transferred over to the seller? The next is the earnest money deposit. How much would that earnest money deposit be, and how is it being transferred over to the seller? These can be cash, personal check, official bank check, wire transfer, or an electronic transfer. If you're doing an electronic transfer, example like a Venmo or a Zelle, those can be done, but verify with the buyer if they are getting a loan that the lender is okay with those means of transfer. Eventually, all lenders, I feel, will be okay with it, but right now there are some lenders that are not okay with an electronic transfer of those means. So if that is an option, you want to get before you send it. Next would be an additional earnest money deposit. An additional money deposit. Why would we have a number of reasons? A good example of that might be if buyers make upon acceptance date, they'll turn over an earnest money deposit, and then after 1 week, they may be turning over the additional earnest money deposit for some reason that may be adequate financial situation stands. So if that is the case, that's where that would go. The next line is assumption. Is the buyer assuming a loan? If so, how much is the balance of that loan that they are assuming? Next is seller financing. Is the financing a portion of this purchase price? If so, what is the balance that the seller would be financing would go there? Next would be building deposit. Is it a new construction and that there is a building deposit put down? If that's the case, then you want to include the new construction addendum, or maybe go to the offer to purchase for new construction. But if that is there, then that would be put there. Now, once you take all of those columns, subtract them from the purchase price, the last number would be the balance, which would be the amount that would be owed at closing. Taking the purchase price, that balance would go there. At closing, or if the contract were to terminate or any other thing happened to the contract, however that money would be distributed, which would be agreed upon with all parties. The next section is the escrow agent. Who is the agent that would be holding that earnest money deposit? That's what goes into that blank line. Is it one of the buyer or seller's real estate firm? Is it a closing attorney? Who would be holding that earnest deposit? That goes in there. Blue box, if there's ever a dispute between buyer and seller over the earnest money deposit, that earnest money has to be held in that escrow account until all parties agree and settle that dispute. If the dispute cannot be resolved, then eventually that money will be turned over to the clerk of court, and the clerk of court will hold it until it is resolved. Effective date, moving on to the effective date. The effective date of this contract is when both buyer and seller have both signed it and buyer and seller have been sent a copy of it. It does not have to be a hard copy, it can be an electronic copy. Hence the mailbox rule that we all learned in pre-licensing. Once that has been emailed or sent over to the other party acknowledging that it has been signed, that is the effective date, and that is when the contract is now complete and enforceable. Due diligence and due diligence fee. Due diligence is the period that the buyer is encouraged to do all of their diligence on purchasing this home. Example, a home inspection, appraisal, anything like that that they want to do. There is a material breach by the seller. If there is not a material breach by the seller, the due diligence fee is not refunded back to the buyer. That fee they will not get back. Now, if you read down, and during the due diligence period, the buyer has the right to terminate during that due diligence period, and if they so elect to do that, then they are entitled to get the earnest money back. The earnest money can then be refunded back to them as long as they terminate during that due diligence period. On to the next page, we're talking about the due diligence period. How long is that period? That period will begin on the effective date, and you have two options. It can be a hard date, that due diligence period ends on this date, or if you think this contract may be going back and forth with negotiations, may take a couple days to sign and execute, then you have the second option where you can put due diligence period runs through an X number of days from the accepted date. Now, if you feel like your contract's going to be accepted the day you're writing it or maybe the next day, then you may be able to put in a hard date, like for example, February 1st. If you think this contract may be negotiated or maybe days before you can get accepted, then you may want to put in the due diligence period runs 21 days after acceptance date. That would be an example. All of these you would want to discuss with your buyer, give them the opportunity, explain how much time they may need, depending on what they may need to do during their due diligence period, will depict depending on possibly how long you need that period. Now remember, if you make that due diligence period a lot longer, that can become less appealing to a seller. So there are pros and cons both ways, but again, it is up to the buyer to make an offer of what they feel is appropriate for their due diligence period. Next, we're going to move into settlement and settlement date. Settlement is when all the appropriate documents have been finalized and everybody's ready to close and the transfer of title happens. Settlement date, what date does the buyer want that settlement date to happen? Just like the due diligence period, everything is negotiable. So just because a buyer may want a settlement date on one day, the seller may want it on another day, it can be negotiated. But at what time what date is this scheduled to possibly close? That would be the settlement date. If there is a blue box, if there is a delay in closing, then we'll get into that when we get into paragraph 12 as that blue box states. Moving on next to closing. Closing is the completion of legal processes in which everything has been finalized, everything has been signed off on, and the property title is moved from seller to buyer. All right, next we have the big red box talking about North Carolina State Bar has determined that performance of most acts and services require a closing and a practice of law to be performed by a licensed law attorney, real estate attorney. You will need an attorney to help consummate and close this deal. We as real estate agents cannot do that. We are told we cannot do that. We're not attorneys, so you need to hire the professional services of an attorney to handle the closing. Moving on to letter N in this section, special assessments. A special assessment is a charge against a property by a governing authority, and if there are any, we need to make sure that they are relayed over and information is relayed to the buyer. We will talk more about special assessments when we get into paragraph 6A. Fixtures and exclusions. This bottom of this page moving into the next page talks about fixtures and if there are any fixture exclusions. Fixtures are anything that is built into the house, nailed in, comes with the home, things that are made and fit with that home. All of those items should be conveying with the home unless explicitly wrote out in the next section. We have a bunch of bullet points on page 4 about what are fixtures. Prime examples of those: keys, garage door openers, your doors, your appliances. Now, when it's appliances, does not include refrigerators and washers and dryers. Those are considered personal property of the seller, but any other kitchen appliance that is built in, like the stove, a built-in microwave, dishwasher, those appliances would be conveying. Light fixtures. If there's any things that, if you have, and a great example would be is if you have a bookcase that is built in and nailed into the wall, that would be considered a fixture. Now, a nightstand is not a fixture, that's personal property. But you just want to make sure that the seller understands that unless it is written in here that these items do not convey, they all need to stay with the home when the home is transferred to the buyer. Talking about other fixtures, let's move on to unpairing and deleting data from devices. Ring cameras, cameras on the outside, camera floodlights, all of those are fixtures. Those are supposed to stay with the home. A seller is required to delete all of their information off of it and unpair themselves from those devices. So that way when they sell the home, they can no longer access the cameras to someone else's home. So seller needs to know that by the time that house closes, they need to unpair and delete all of their information off of it. Because they also don't want the new buyer, when they take over the home, to have access to any files they may have saved from cameras that have happened while they owned the home. So you want to make sure that's all relinquished. Items leased or not owned. If there are any items that are leased or not owned that are conveying with the home, that is where we will fill that in right there. What would be an example of that? A great example would be as if the seller has rent-to-own appliances. Sometimes people will go to a rent-to-own place to get their refrigerator, their dishwasher, their microwave, their stove. They'll be a rent-to-own. So at that moment, they may not fully own them. If there still is leased payments or money owed on it, it needs to be notated here, and it needs to be paid off prior to closing unless agreed upon by all parties. The next section, other items that do not convey. This is where a seller would put something that they are taking with them that may be a fixture. If there is a sentimental chandelier in the dining room, a chandelier is supposed to stay with the home. But if the seller wants to take that, they have the right to take that. But if they are going to take it, it needs to be written out in here and make it specific. Whatever brand it may be, Tiffany brand chandelier in the dining room. That way it's known which chandelier that is. You don't want to write just light fixture. That's not specific. We want to make sure it's specific. So that way we know. And make sure that, again, all parties have to agree upon it. Now, a big question talking about this is when the listing is in the MLS may say on the listing that there is a fixture exclusion that is not conveying with the house. Now, if that is on the MLS and is not transferred over to the offer to purchase, then it is going to stay because the offer to purchase is going to trump the listing if there is something in the offer to purchase that is also in the listing. So just make sure if there is an exclusion in the listing, you also have it in the offer to purchase. All right. Number 3 on this one is personal property. Is there any personal property that the seller is going to be leaving or conveying with the home to the buyer? That may be the example of a refrigerator or washer or dryer, or maybe the buyer wants the couch in the living room or a dining room table or something. Is there something like that that they are leaving? If there is, and it is an item of value, you may want to run that item by the buyer's lender if the buyer is getting a loan, because sometimes depending on the item, the lender may throw that back and say, we can't have that in this contract because it looks like they're getting a loan for a house and personal items, and loans are just for the home and the property. So if there are big ticket items on there, then it may not be able to put it in here. You may have to do an additional bill of sale for those items, so that way the contract is lender compliant. All right? Because that's, kind of what it said in the blue box, that any personal property that will be part of this sale should be identified in this paragraph. Buyer is advised to consult with buyer's lender to make sure it is okay. Next, we'll move on to buyer's due diligence process. The buyer's due diligence process. This is when the buyer is encouraged to do all of their due diligence, whether it may be a home inspection, an appraisal, finding out about homeowner's insurance, how much that would be, and assuming it is insurable, survey, anything like that that they may want to know. Is the home in violation of any governmental compliance issues or anything like that? Is there any other information that the buyer needs to know about this house to make sure this is the home that they want to purchase, and they are fully up to date on everything that this home has and is coming with it to make sure they still want to move forward with the process. All of this information is encouraged to be done during the due diligence period. So that way, if the buyer finds out something that is a deal breaker and that they need to terminate this contract, and they can have to do that under that due diligence period, so that way they would still be entitled to their earnest money back. Now, this is also when if you're getting a loan, you want to make sure you get your loan application moving, get your loan going. The process for that can be time consuming. So you may want to talk with your lender, find out how much time does a lender need to finalize the loan to make sure you can correlate that with the amount of due diligence period you are requesting. Same thing with your inspections, your surveys. If you're doing any of that, you want to kind of find out how long those may take, so that way you can make sure your due diligence period correlates with those time frames. And there's the whole list of all those different things that the buyer may be doing during that period. All right. Next, we're moving on to sale, lease of existing property. All right, so per the North Carolina contract, this contract is not contingent on the sale or lease of another property that the buyer may own, unless specified onto the next section. But as of right now, it is not. Repairs, improvements, and negotiations. The property is being sold in its current condition. That is North Carolina contract, that all properties are being sold as is in their current location and their current condition. Seller may not be required to engage in negotiations for repairs and improvements. That doesn't mean you can't do them, but just the seller has no obligation to be involved in any type of negotiations with repairs or improvements. Buyer's obligation to repair damage. Now that basically states that if the buyer or anybody working for the buyer were to damage the property, the buyer would be responsible to repair those damages. The example of that would be is if the home inspector is there and the home inspector breaks something, that would be the buyer's responsibility to make sure that is fixed. Indemnity. The buyer will indemnify and hold the seller harmless of any loss, damage, or injury from the buyer or any of the buyer's contractors or any people that may be with the buyer. So a seller is not responsible if you go to a house and you trip and fall. You're holding the seller harmless. That is not, you can't really go after them and sue them. Now, caveat to that is that does not apply if the seller has negligence and did not warn you of that negligence. Like an example of that would be is if there's a hole in the floor and the seller covered it up with a rug and then you step in the hole and get injured. That can be negligence, therefore the seller could be responsible for that. But if you are just walking around and get hurt or lose something or damage something of your own, that the seller is held harmless for those. Buyer's right to terminate. The buyer has the right to terminate during the due diligence period for any reason or no reason at all. They don't have to have a reason, but they have the right to terminate inside that due diligence period, and if they do, they are entitled to that earnest money back. Now, if they terminate after the due diligence period, they still have the right to do that, but at that point, now the seller can go after damages. Example of those damages would be the earnest money deposit. That can then be relinquished to the seller as those liquidated damages for the buyer terminating after their due diligence period. All right, let's move on to buyer representations. How is the buyer going to purchase the home? First option is cash. Are they purchasing the home with cash? If not, next would be a loan. If they're not getting cash, they're obviously getting some type of financing. You need to disclose that first mortgage. Is it FHA, VA, conventional, USDA, or another type? What type of loan are they getting? Are they getting a second mortgage loan also? If so, what are the means of that second loan? That is all the material facts. That all has to be disclosed because the seller needs to know, how is the buyer paying for this? Now, just because they're getting a loan, again, North Carolina contract states this contract is not contingent on buyer's financing getting approved unless there is an addendum stating that. If there's not an addendum stating that, this contract is not contingent on the buyer's loan. Talking about the other property, this is where we just talked about, does the buyer have to sell or lease another property prior to closing on this deal? Now, this contract is not contingent on that, but if it is for the buyer to be able to close it, we need to know, does the buyer have to sell or lease that other property? And if so, is it actively for sale or lease, or is it under contract? What is the status of that other property? When does it close or finalize? That may be something a buyer wants to make sure that gets done in their due diligence period to make sure that they have that taken care of so they now have the funds to close. Performance of buyer's financial obligations. To the best of the buyer's knowledge, there is no other circumstances that would exist as of this date that the buyer's financial obligations would not be able to be performed. So unless set forth herein, is there any other reason that the buyer's obligations cannot be performed? The buyer is stating that there's not. Moving on to disclosures. We have two disclosures that are always going to accompany this offer. The Residential Property Owners Association disclosure and the mineral, oil, and gas rights. Has the buyer received a signed copy of those from the seller? Yes, no, or is it exempt from these? Now, it may be exempt, the property disclosures, for two known reasons, and those two would either be new construction or foreclosure. If it's one of those two, then it's probably exempt from this. But other than that, has the buyer received a signed copy of this? If they have not received a signed copy of this, then they have the right to receive them after this contract is accepted, and if they receive it, they are supposed to receive it within 3 days. And once they receive it, they have the right to then terminate if they learn something on those disclosures that is not appealing to them and they don't want to move forward. So it is encouraged to try to get those prior to this contract, so that way that is all taken care of. But sometimes if you don't have them, you don't have them. So you just need to notate, has the buyer received a signed copy from the seller, yes or no? All right. Number 6, buyer's obligations, responsibility for special assessments. If there are any special assessments that are approved following closing, the buyer takes those special assessments. Now, we'll talk about the special assessments on the seller side when we get to the seller side. But as far as approved special assessments, if there are none, but they get approved after closing, the buyer's taking responsibility for those. The buyer's also taking responsibility for certain costs. Anything that the buyer has to pay to do their side of this due diligence in this contract? Are there any fees associated with the loan, the appraisal, the title search, title insurance, closing attorney fees in preparation of the closing disclosure, recording of the deed, preparation of any recording instruments, anything like that that pertains to the buyer. The buyer understands that that would be something that they will be responsible for. Authorized to disclose information. Buyer authorizes the buyer's lender, the attorney, and the agent on the deal to disclose information that is needed to close this deal and to make sure this contract goes to closing. Buyer understands that there may need to be information relayed amongst different parties. As long as it pertains to getting this deal closed, buyer authorizes that information to be shared with the appropriate parties. Now we'll get into seller representations. First is ownership. How long has the seller owned the property? Has they owned it for at least 1 year, less than 1 year, or does not yet own the property? That needs to be notated there. You can find that probably in the listing because the listing requires that to be relayed on the listing itself. So you can look on there and find out. So find out which one that is and make sure the appropriate box is checked. Next would be lead-based paint addendum. If this house is built prior to 78, then the lead-based paint addendum will be required to be attached with this offer. If so, you will check that box. If it is not required, the home was built after 78, then you will not check that box because the lead-based paint addendum does no longer apply. Owners associations and dues. This goes under seller representation. The seller will do what they can to provide all of the owners association documents and information and dues to the buyer and the closing attorney and the buyer's lender. They may need counts of the financials of the HOA. They may need the bylaws, the CC&Rs. Are there any parking restrictions and information, any architectural guidelines, anything like that? Seller's going to do their best to provide all of that to the buyer. With that, we have what is the HOA? If there is an HOA, we need the name of the association. What are the dues? How much are the dues and how often are those dues paid? And then who is the association manager or the president? All the information that the seller has for the HOA. We need all that spelled out right here. There's 2 spots for an HOA. Sometimes there may be 2 HOAs. If there is, you need to spell out both of them. What are the 2 HOAs? What are their dues? How often are their dues paid? That way it's all in here. Number D here, fuel tanks and fuel. Is there a fuel tank that is conveying with the property? If so, where is that tank? Is it in use or not in use? And is it owned or leased? Where is the location of it and what type of fuel is in it? And then last is the contact information for the fuel vendor. All that needs to be known and notated. Fuel vendor is required because only a licensed fuel vendor is allowed to fill up and maintain the fuel tank. You cannot just have the next door neighbor come over and fill up the fuel. It has to be done by the fuel company. So we need to know who that is. We need to know where that tank is, who owns it, is it leased, and how much fuel costs and what goes along with it. Because the tank obviously is going to convey with the house, and so will the fuel that is left in it at closing. If there's any fuel left in it at closing, the seller cannot have that tank emptied and sold back to the company. That fuel is considered a fixture and must stay in the fuel tank. Now, if the seller uses all the fuel, that's different. They're not required to fill it up. But if there is any fuel left in the tank, they are required to leave that fuel there. All right, now let's talk about leases. Is there a lease on this property? Yes or no? If there is, then it would be a good idea to have the additional provisions addendum attached stating the terms of this lease. Do we have copies of this lease? If there's not a lease in place, then just check there's not a lease. Seller's obligations. Let's get into evidence of title, payoff statements, and non-foreign status. Talk about evidence of title. We want to make sure that as of closing that we are able to perform and give the buyer a good general warranty deed on the property. Access to that title insurance that may be on the property. Payoff statements. Sellers needs to provide the closing attorney payoff statements, or a buyer's lender, or even the buyer payoff statements if requested, to make sure that anything that is owed on the house, the seller pays off prior to closing. And then non-foreign status. If the seller is under the non-foreign status title, the non-foreign investment tax, if they are under that, we need to know that, because if they do not pay the taxes for this sale, then it is possible that a closing attorney may withhold some of the seller's proceeds for that tax. So the seller needs to be aware of that, if that applies to them. On the seller side, authorization to disclose information. We're on page 10. Seller authorizes the attorney, the buyer's lender, the real estate agents on both sides, that if any information needs to be disclosed amongst those parties, seller gives permission for those parties to disclose information to each other pertaining to getting this deal closed. Just like the buyer, the seller has to do the same. All parties agree that if there's any information needed, all parties agree to have that information shared, so that way this contract can be held up and closed. Access to the property. The seller has to give the buyer access to the property to do their due diligence, to do viewings, to do showings, to do walkthroughs. The seller does not have to give access to the property 24/7, but they do have to give access to the property within reason for the buyer to be able to do their due diligence. They can't do any of this if they don't have access to it. So seller needs to let it be known that they need to give access within reason to the buyer to do their due diligence and have access to the property to do those such things. Removal of seller's property. As of closing, the seller understands that they need to remove all of their personal property and trash and debris. So that means when they move out, they can't just leave trash everywhere. They have to also remove all of that. So the seller needs to be known that they have to remove all of that, all of their personal property inside and outside the home. Buyers don't want to take a house full of trash. So make sure it's all removed. Affidavit and indemnification agreement. At closing, seller will sign one of these. What does this state? This states that if there's been any work done on the home, anything like that, the seller has paid those people. So no one can come back after closing and say, oh, I was owed money for work I did on the home. Because any lien like that, a contractor has up to 120 days to file a lien against the property for monies they may be owed for work done on the property. Seller will acknowledge that if that is the case, they have paid those people. They've been paid in full, so that way no one can come back and file a lien against the property for something they may have done. Designation of lien agent, payment and satisfaction of liens. Satisfaction of liens. If there are any liens, everything will be paid off. Satisfaction. They have been taken care of, so that way the buyer's not taking on any of the seller's debts. Good title, legal access. This goes into the general warranty deed again. Make sure that we are transferring a clean title and general warranty deed to the buyer at time of closing. All right, blue box here under this one. Buyer's failure to conduct a survey or examination of title prior to the due diligence period does not relieve the seller of their obligation to deliver good title. Just because a buyer may not do any of these things does not mean the seller now has a right to not give this. They still have to make sure that they give a good, clean title. All right. Moving on to page 11, government compliance. That is this property free of any material violations, laws, ordinances, government regulations, anything like that. If so, that needs to be known, but by the time that closing happens, we need to make sure all those have been resolved. All those have been taken care of. Everything is fine and clear, so the buyer can take that title. Deed, taxes, and fees. How is the buyer taking that title, that deed? This is where you would put the buyer's name. You know, is the buyer taking it in their personal name? Is the buyer taking the deed into a S Corp or an LLC? How is that buyer taking that deed? That's where that would be put. Agreement to pay buyer's expenses. Is the seller paying any of the buyer's expenses? If so, what is that dollar amount? That would go into that line. If the buyer is getting an FHA or VA loan, you want to make sure that that amount does not exceed what the lender allows. And also, there may be certain inspections that the VA, example, requires a termite inspection that has to be paid for by the seller. That would go into this line. The cost of that inspection would go there because that has to be paid for by the seller, cannot be paid for by the buyer. So things like that, whatever those dollars amounts, would go into that line. So if there are any things like that that pertain to any type of loan, make sure you review that with the lender to make sure whatever's put in there is appropriate. Owners Association fees and charges. The seller shall pay all charges associated with the HOA or management company per this contract. Payment of special assessments. If there are any confirmed special assessments prior to closing, the seller will pay all of those off in full prior to closing. Are there any late listing penalties? If so, that also should all be paid for by seller. Negotiated repairs and improvements. If there are any negotiated repairs and improvements, they were done in a good workmanlike manner. Now, like it said earlier in the contract, the seller is under no obligation to do any repairs or improvements, but if there are negotiated and agreed upon repair improvements, they have been done in a good workmanlike manner, and the buyer has the right to re-inspect those repairs or improvements prior to settlement. Home warranty. Is the seller providing a home warranty? Is the buyer obtaining a home warranty to be paid for by the seller? These are the three options. Either no, there's no home warranty coming, or yes, the buyer is getting a home warranty that the seller is paying for, or is the seller already providing a home warranty to the buyer? If so, that needs to be put in there. Seller's breach of contract. See paragraph 23 for remedies. We will get to that one in a little bit. Charges by owners association. Are there any charges by the HOA that pertain to sale of this home? If so, the seller shall pay all of the ones that would be for the seller, which may be if there are any fees included for the HOA to complete the residential property and owner association's disclosure or resale certificate. Are there any dues or assessments that need to be paid for? That would be the sellers. If there's any transferring or updating of ownership, that may be paid for by the seller. Buyer, though, may have to pay some if there's any fees that the lender has to pay in order to get information from the HOA. Because the lender's requiring it, that may be the buyer's responsibility. Are there any working capital contributions or membership fees? Or charges for determining restrictive covenants compliance. Anything like that, that may be the buyer's responsibility to pay for. Number 10, prorations and adjustments. Everything will be, of course, prorated at the time of closing. What are some of these prorations? Taxes on the property taxes. Taxes on personal property, rents, or dues, like HOA dues. Because the seller is responsible from everything on the calendar year from January 1 through the day of closing, buyer's responsibility is from the day after closing through the end of the year. So if there is a lease in place, the rent will be prorated for that month. The part of the month that the seller owned it, the seller will retain that rent. The part of the month that the buyer owned it, the buyer will be entitled to that portion of rent. Same thing with property taxes. Seller has to pay the property taxes through the day of closing. Buyer is now responsible from the day after closing through the end of the year. It is all prorated. Condition of property, risk of loss. So the condition of the home, in order to be compliant with this contract, has to be either the same or better condition at closing as it was when this offer was accepted. If it is not, then the seller could be in breach of contract. If it is not in the same condition because of some type of acts like fire, flood, anything like that, the buyer can terminate and would be entitled to a refund of their earnest, their due diligence, and any other fees within reason that they may have had to pay to try to buy the home. Now, the buyer can still take the home if they choose, and if there is any insurance payouts, the buyer can receive those insurance payouts after closing, because that's what it states also in risk of loss. If the home were to be totally burned down and destroyed, the buyer could still take the home and collect that insurance premiums after closing. If they choose not to, the seller is then in material breach, and the buyer would be entitled to terminate and be refunded all their monies. Delay in settlement and closing. So in this contract, there is a 7-day built-in delay in settlement and closing window that either party has the right to delay closing up to 7 days for some reason that they may not foresee going in, but if something comes up, they have that 7-day window. Now, if that window has been reached and it goes past that, then the party that is not in delay has the right to terminate the contract, whether that be the buyer or seller. If it goes past that, you need to make sure, if all parties agree with it, we need to do an extension agreement to amend contract. Let's change that closing date to when we need it. Make sure that's addressed if you feel like that window is going to be reached. But if it does go past that 7 days, it takes both parties have to agree. Possession. Unless otherwise specified, the buyer will take possession after settlement. If there is a different type of possession that's taking place, this would be where these addendums may come into play. Is the seller keeping possession after settlement, or is the buyer taking possession prior to closing? If that is the case, the addendum needs to be attached that would be spelling out those terms. Or are there any other addenda that are accompanying this contract? If so, these are a list of different addendas that could accompany this offer. If so, you want to make sure the appropriate box is checked. If there is an other addenda that is not on this list, there is lines to fill that out. Now, as we all know, a real estate agent is not allowed to create their own addenda. If there is another addenda that is attached to this, created by an attorney. Attorney needs to create that addenda and then spell it out what that addenda is. Assignments. This contract may not be assigned to another party without all parties' approval. Tax deferred exchange. The only time this can be assigned would be as if it's part of a tax deferred exchange, like a 1031 tax exchange. That can be applied, and that, if it is the case, all parties will do what they need to make sure that happens. Moving on to page 13, parties. All parties of this are binding for the buyer and the seller and their respective heirs, successors or assigns. Survival. If there is any addenda that may be surviving the settlement or closing of this, and it goes into play after closing, it will survive the consummation of this deal. It still may be in play. Example of a agreed upon repair or improvement that may be paid for by the seller taking place after closing. Just because the property closed, if that addenda with agreed upon repairs or improvements is in play, that will survive of this contract. So this is the entire agreement, and it will be recorded as such. Conduct of transaction. All parties agree that they will conduct themselves professionally and abide by the code of ethics, and that they will conduct this transaction to get it consummated. Execution. This contract may be signed in multiple originals or counterparts, but they are all into one. It is the same in one time of day. All days that are computed in this are calendar days. They are breached by the seller. If the buyer breaches, the seller can be entitled to liquidated damages, which would be the earnest money. If there is a breach by the seller, the case, you definitely want their monies back. They could have the option of attorneys. If there are attorneys associated with remedies brought to them because one party breached, the prevailing party could accrue those in fees and have the non-prevailing party pay those attorney fees. Page 14, signing page. This is where buyer and seller all sign the contract, which makes it finalized and complete. So that buyer and seller signed it, and all buyers and sellers have signed it. All right. Page 15, big red